So what do we make of the fact that two separate Supreme Court judges have actually exited from Reliance-related cases? Let's get straight into our debate this evening. Let me start with Ryan Karanjiwala. Ryan, do you see this as a healthy sign? Because it's raised a lot of eyebrows, caused a lot of debate. Many people believe that it's a sign of greater transparency, that it is better to put possible conflict of interest out there in the public domain.
No, well, it's always good to put a conflict of interest out there in the public domain. Here, I think both the judges have gone a little beyond what is the normal protocol.
Why do you say that?
I'll tell you this. I myself have been have a firm in which at various points of time different judges' children have worked. Now, what is the normal protocol of such a situation? The normal protocol of such a situation is this, that you inform the registry and the judge also informs the registry, and the judge never gets to hear any case which that particular firm handles. And that's all. That's where the matter ends. There's no question of, otherwise what would happen is this, that every week I have to give to the registry a roster of my clients, updating them as to which are my new clients. And every week they would have to keep checking as to whether any matter of that client handled by another advocate was before the judge whose relative worked with me. And it would become an impossible situation. The registrar would just constantly be monitoring the different rosters of different firms.
So you're saying it's setting a kind of bizarre sort of precedent?
No, what I think has happened is that because this is a particularly sensitive case, because this is a particularly high profile case, the judges have been more cautious than they would normally be. There never is a situation where a client being dealt with one firm, which has a judge's child working with it, cannot litigate before the judge when he's represented on another case when he's represented by another lawyer.
All right, let me take that point to Prashant Bhushan. Prashant Bhushan, respond to that in the case of Justice Raveendran especially, although his daughter was working with the law firm that counsels Reliance, it was not on a related matter. Ryan Karanjiwala here making the argument that, look, this should not mean, transparency should not mean that everybody, familial links in a sense should be examined every time there's a case when the case is not related to the matter that's being heard.
No, I don't agree with that. I think a judge or a judge's son having a company for a client and whether that company's case can be dealt with by that judge, I think that is a conflict of interest. And in my view, the judge in these circumstances should recuse himself, because if the judge's son or daughter or brother or wife has a client which is a company, and that company is paying that person, then there's certainly a conflict of interest, because clearly that judge's son, daughter, wife, etc. is getting money from that company.
Tuba.com